And receiving an adverse decision from USDA can feel overwhelming. Whether it's a loan denial or payment rejection, these decisions can impact the farm's future. Fortunately, there is a structured path to challenge these actions. So Roger McEowen with the Washburn School of Law joins us with some guidance. So we appreciate you again this morning, Roger. Kind of first, talk to us about the National Appeals Division and what can all be appealed.
Yeah, well, good to be with you, Eliza. And I noticed all your opening stories this morning, every one of them's ag law. So it's very, very relevant to everyday life for a farmer and rancher. But Congress enacted the NAD, the National Appeals Division, back in 1994 to bring some consistency to what was then a checkerboard of appeal procedures across the USDA's various agencies at that time. And of course, the primary goal of the NAD is to bring efficiency and transparency and fairness to the USDA's internal appeal process.
And I know that crop insurance disputes can be a highly specialized process when it comes to this. So what do farmers need to know to navigate that scenario?
Yeah, you're very right there. It is a highly specialized process. And so the correct path in terms of appealing an adverse crop insurance decision, it depends entirely on who made the determination and the nature of the dispute. For disagreements that regard a claim denial or an adjustment by an approved insurance provider, the claimant generally is stuck with the contract that they signed. They're generally required to follow the dispute resolution provisions that are in the policy. Now, if the risk management agency, which is an arm of the USDA, is involved, such as involving a determination concerning a good farming practice, then the determination of whether RMA has modified a claim, that's going to shift the process into the NAD, and then that appeal has to be filed within 30 calendar days of receiving the adverse decision.
Interesting. It sounds like it can get complicated pretty quickly, especially when we're dealing with the USDA, of course. So for a farmer dealing with this, kind of what's the first step? Do you go to your FSA office? Do you go online somewhere? Kind of what does that appeal process really look like for a farmer?
Well, it's a very structured administrative process. So you're going to start at the county level, you're going to work your way through the state level before you can get to the NAD. But the real key is to understand the timeline, and the evidence building in terms of building a record of evidence is a key to a successful outcome. You've got to file an appeal within 30 days of receiving an adverse decision. And I can't tell you how many times I've seen those come to me on the 29th day or the morning of the 30th day. You've got to pay attention to that deadline. Then there's going to be an administrative judge that's assigned to the case, and you're going to have a pre-hearing conference. You're going to have your conference. And then if you get an adverse decision, you got another 30-day window to get director review. And you got to go through all that process before you can get to a court. So a big takeaway for a farmer is get legal counsel early on.
Really good information, as a lot of our farmers, unfortunately, probably will have to deal with this year, of course, so all great insight. And you mentioned earlier a lot of our headlines. It all surrounds ag law, of course, from the Farm Bill to things happening in the Supreme Court with glyphosate. So before we wrap, as you know, the Supreme Court heard oral arguments this week in a glyphosate-related lawsuit that really could have big implications for farmers. So I know you've been really in tune with this. Kind of what's your outlook as this case moves forward?
Well, to frame it for people, the focus of the Supreme Court is on whether federal pesticide labeling law preempts state-level failure to warn lawsuits. And so for farmers, the decision, whatever the Supreme Court says, is going to be critical. It represents the tension, I think, between regulatory consistency and the legal right to challenge safety standards. So we wait to see what the court and, as you indicated, what the Congress might say on this.
Right. Something we're definitely following is, could really shake up our labeling system in place and could mean a lot for our farmers. So Roger, as always, really great insight this morning. We appreciate you joining us. Roger McEowen with the Washburn School of Law.